Can you walk us through the process of filing a VA claim for a terminal condition? Just the 30,000-foot view.
Sure. Well, the basic process is similar to filing any other VA claim. You have to file on the appropriate form. Typically, this will be a new claim, so it'll be Form 526EZ, but it could be another form depending on exactly what you're filing for. But there is also a supporting form that the VA uses to help them identify and track claims where the veteran is explaining that he or she is terminally ill, and so you would typically want to file that form also.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Attorney Francis Jackson.
Welcome to Victory Over VA, your guide to unlocking your veterans' disability benefits. If you're a veteran applying for benefits, be sure to subscribe to our podcast for the latest developments in VA disability. I'm Francis Jackson, this is Kristian Terison, and we're veterans' disabilities attorneys at Jackson & MacNichol, where we've helped thousands of veterans to win millions of dollars in benefits. We created this podcast as a resource for veterans who are applying for disability benefits, folks who need to get justice on their claims. But it's also for anyone with an interest in veterans' disability issues, whether you're a family member, a community member, a relative, or anyone else who wants to understand a little more about the disability benefits available to our veterans. Today's show is about benefits for those, sadly, who are terminally ill. And with that, sir, let's start.
All right. Yes, sadly, it's something that happens more than we'd ever like to see, where a veteran will be filing a claim for a condition that they believe is service-related that's also terminal, certain types of cancers, certain severe respiratory conditions. But can you walk us through the process of filing a VA claim for a terminal condition, just the 30,000-foot view?
Sure. Well, the basic process is similar to filing any other VA claim. You have to file on the appropriate form. Typically, this will be a new claim, so it'll be Form 526EZ, but it could be another form depending on exactly what you're filing for. But there is also a supporting form that the VA uses to help them identify and track claims where the veteran is explaining that he or she is terminally ill, and so you would typically want to file that form also.
Okay. And does that form, I mean, it's a VA form, does it have a
It has a designating number. It's a 20-10207.
Okay. And does that form trigger any special considerations, expedited processing, things like that, when a claim arrives at the VA?
It does trigger special consideration. That's a generic form for expediting claims, but it has a special section, kind of the second section down if you're looking at the form, that is specifically for claims involving terminal illness. And so what is supposed to happen when that form comes into the VA is that if there is supporting evidence with it showing that in fact there is medical evidence of a terminal illness, the VA is supposed to give that expedited processing right from the beginning. As we'll talk about, there are some wrinkles to that, but that's how it's supposed to work.
Okay. And I mean, you mentioned medical evidence. I know we've discussed medical evidence at length in several other episodes generally, but what kinds of evidence are most helpful when a claim for a terminal illness is at issue?
Well, the best thing is a descriptive letter from a physician saying, you know, this veteran has this particular condition. It appears to be related to service, and a brief explanation of why, and this is a terminal illness. it is anticipated that it'll be fatal within X period, whatever X period may be, whether it's weeks or months or hopefully years. But, it is a condition that is expected to end in death within a foreseeable period.
And also, I think at this point, it would be good to mention the evidentiary standard because, going to your physician and asking for that type of letter, the evidentiary standard is at least as likely as not. So can you talk a little bit about what that means?
Sure. When you are dealing with the VA for a veterans benefits claim, there are 3 requirements. You have to show a current medical problem or disability. You have to show an incident or illness or some other connection to your time in service. And you have to show a medical link between those 2. It is helpful in terminal claims to have a single document that the VA can look at where a physician talks about both the connection to service and the fact that the condition is terminal. In dealing with the VA, you have to recognize this is a huge bureaucracy, and the more you can keep it simple and to the point, the better off you will be in terms of getting the claim moved quickly and efficiently. So if you have a single letter from your physician explaining that he is your physician or she is your physician, explaining that you're being treated for this particular condition, explaining how they believe it is related to your service or why they believe it is related to your service, and explaining that it is terminal, cover those points, that is the best possible evidence. Now, in support of that, medical evidence showing that you were treated for this in the service, or medical records showing you were exposed to the underlying carcinogenics, if it's a cancer case, in the service, and that sort of thing, will certainly help. That the more you support what's in the doctor's letter, the better. But you really want a nice, clear, short statement. This is the veteran, this is the condition, it's a terminal condition, it's related to service, and here's why. The more you can get a physician to write a letter in that kind of concise way, but with that much detail, the better off you'll be in terms of making this go quickly.
Yeah, and one of the things that I've seen in my own cases is that the evidentiary standard becomes so important because, 9 out of 10 doctors who will approach with an issue like this, they'll say, well, there's just no way of knowing. And I'll say, well, is it a 50-50 that, it could have been this other factor or it could have been service? And the doctor will say, absolutely, there's no way to pick a winner.
Yep.
And you say, perfect. Are you willing to put that in a letter? And they'll look at you and say, well, yeah, I'll put that in the letter. I won't say this was caused by service, but I'll say it was either caused by service or this other thing, and nobody can tell which medically.
And it's at least as likely that it was this. Yep.
Yep.
I hate to use cancer as an example because it's such an unpleasant disease for people to deal with. But, cancer cases, I can't tell you the number of times we've seen the issue of, well, this person is a smoker, this person was exposed to, take your pick, Agent Orange, asbestos, whatever it is that's causing the cancer, and we can't say which one caused it. Well, in the VA system, the doctor doesn't have to say which one caused it. All the doctor has to say is that, look, we know that this exposure to Agent Orange can cause lung cancer. We know that smoking can cause lung cancer. There is no way in any particular one case to say that it was the smoking or it was the Agent Orange exposure. We know both of them will get you the same result. So all the doctor has to say is, yes, there's exposure to Agent Orange. Yes, there's smoking. We know both of those can cause cancer. It is at least as likely as not that it was the Agent Orange exposure that caused this particular cancer. And no one can ever tell which one it actually was, but it's at least as likely as not that it was this exposure.
Right.
That's all that's required for the veteran to be entitled to benefits in the VA system.
Yeah. And, historically, doctors and lawyers aren't two professions that get along very well. But this is one of the times where, the doctor can write in their, medical opinion without restraint, gee, I don't know. It's at least as likely as not. And that's all we're looking for. So, if you want to download this podcast episode on your phone, bring it to your PCP, play them a couple of clips, and they'll look at you and say, just at least as likely as not. Say, that's all I'm looking for in the letter. Maybe that will be the thing that pushes your case over into a grant.
Yes.
So another perennial issue, particularly with a case of terminal illness, is timeline. Mm-hmm. So, for somebody who's at that first step, filing the 526EZ, what kind of times are they looking at right now?
It depends a great deal, unfortunately, on where you are. Well, actually, that's less true than it used to be. More exactly, it depends a lot on where your case gets assigned. The VA now has what they call a national work queue. So if you're in Oklahoma, your case may not be assigned to the Oklahoma regional office. It may end up being assigned to somebody in Chicago, but it makes a real difference where your case is assigned. A lot of the larger VA regional offices are simply busier and comparatively less staffed in relation to the volume of cases in their immediate area, which are the ones that they are most likely to get assigned to them. So it can vary a fair amount, but if you submit evidence that the claim is terminal and you specify to the VA that you're asking for expedited processing because this is a claim for terminal illness, it is supposed to go right to the top of the workload and get worked promptly. Now, I can't say that that happens 100% of the time, 100% of the places in the US, but most of the time, most places, that gets honored and it will go right to the top of someone's workload. And if there is supporting evidence showing, number one, that it is terminal, and number two, that it is related to service, it will get handled quite promptly. I've seen cases get resolved within 90 days, which in VA terms is lightning fast. So it can be done. It's just, it has to be really clear and well supported.
And in terms of, again, claims for a terminal condition, are there any deadlines that veterans need to be aware of when it comes to filing?
No, there are no deadlines for filing. The only time a deadline is going to come into play in these cases is if the VA is not convinced either of relationship to service or that the condition is terminal, one or the other of those. If whatever is submitted doesn't convince them of both of those things, then there's going to be a problem. If they're not convinced of relationship to service, the claim's going to be denied, and then it's a real problem because the appeal process can be quite slow. If they're just not convinced that it's terminal, that is probably more easily fixed. Usually, if you have a terminal illness, there is some medical person that you're dealing with who will specify for the VA in sufficient detail that this is truly a terminal condition and give their best approximation of the time within which it is terminal. So that's usually less of an issue. The real problem in these cases is the group of claims where the VA is not convinced that there's a relationship to service. Those are terrible.
And service connection is clearly a challenge that veterans can face when it comes to these conditions. Are there other challenges that you see cropping up in claims for terminal illnesses?
Not usually. I mean, there are so many permutations that you can't say never, but typically the VA is really quite good about focusing on terminal illness claims. And if they have clear evidence of both service connection and the terminal nature of the condition, they can usually move things through pretty expeditiously.
What resources are out there to help veterans who are filing a claim for a terminal illness?
Well, there are actually multiple kind of sorts or groups of resources, but for a terminal illness claim, it is probably most effective, if the veteran's physically capable of doing it, of going to the VA and meeting with one of their internal veteran service officers and providing the material and explaining what's going on. A close second for terminal cases is going to one of the veteran service organizations that has a person, or sometimes multiple people, at the VA regional office. They're kind of embedded with the VA folks. And a lot of those folks have very good working relationships with the VA staff. And if they are convinced that this is a genuinely service-connected condition that is terminal, most of those folks will really do an excellent job of moving that claim through. And, I don't care whether you're talking about disabled American veterans or the American Legion or Paralyzed Veterans of America or Vietnam Veterans of America, any of the other service organizations. I think it is fair to say that all of them really take special efforts to try to move these terminal cases through as soon as they know about them.
And when it comes to benefits, are there any financial assistance or other support programs, offered once service connection is established for terminal conditions that, aren't available for other service-connected conditions?
Well, not really. I mean, what's typically going to happen in a claim for service connection for terminal illness is that the claim is going to be granted, benefits are going to be awarded from the date the claim was filed. And in most cases, if the claim is for a condition that is serious enough to be terminal, the person will be eligible for payment at the 100% rate based on an inability to work, total disability based on individual unemployability. And often the person will be eligible for one of the special monthly compensations, typically housebound or being in need of aid and assistance. But those aren't kind of special benefits for a terminal illness. They're regular benefits, but they're what the VA is going to do in these terminal cases, assuming they have the necessary evidence, is they're going to expedite processing that and getting those benefits, those cash benefits, to the veteran. And there may also be, depending again on the circumstances, there may also be eligibility for the VA's caregiver program for another family member to quit their job and stay home and care for the terminally ill veteran. Those pieces vary greatly based on the condition of the veteran. So it's a case-by-case kind of analysis.
And I know you'd mentioned that, benefits are paid back to the date the claim is filed. So would you say that, a veteran who, when they receive a diagnosis of a terminal condition, should probably go and file the intent to file to begin with, as to give them a little breathing room to gather evidence?
Yeah, if the veteran doesn't have at his or her fingertips all of the information necessary to support the claim, they should definitely submit the VA's intent to file form. What that does is it starts the clock running for benefits, so that the way VA kind of delineates payment periods is by month. So if you file a claim this month, potentially your benefits will start with the beginning of the next month when they process it. So, if you file a claim on the 15th of a given month and the claim is granted, the benefits will start from the beginning of the next month. So, if you are facing terminal illness, you should get either a full claim, if you can do it quickly, or an intent to file in the hands of the VA personnel as quickly as possible, within the same month that you find out about the terminal illness, if possible.
We're just about out of time for today, but I guess what would your parting advice be for veterans or their loved ones who are facing a terminal service-connected condition?
Well, that's a sad topic, but the advice is pretty much a summary of what we've just said. Number one, file as quickly as possible, either an intent to file or the claim. Number two, try to get clear, definitive medical evidence, again, as quickly as possible, about both it being as least as likely as not connected to or caused by service, and being terminal with the physician's best projection of what that means in terms of time frame. The other thing I would add is that if you're one of those poor souls who gets caught in the terrible situation where you have a terminal condition, but the VA is not convinced that it is service connected, if that's kind of the worst of all possible worlds. But if that happens, I would suggest you get expert assistance immediately. The second you get a denial, I would strongly encourage you to find a specialized attorney to assist. I don't normally push the proposition that people need to get attorneys in these cases. I think there are lots of cases where people can get the result themselves. But if you have a terminal condition and get denied, don't fool around. Get an expert, get him quickly.
All right, and I guess with that, we'll conclude this episode today. Thank you so much for watching. Please be sure to subscribe, and may nobody need to watch this episode.
And we hope to see you all alive and well next week.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.